Okay, Tom, welcome back. Last time we talked about the basics of navigating the probate process in Florida. And today we want to get into some more specifics, special situations, details, thoughts about even like avoiding probate if possible. So let's start out with some of these special situations that could occur. Um, Many families are going to have out of state heirs. The parents might even be out of state in Florida. And the personal representative is here, or maybe they're out of state as well. So the parent who they own property in Florida, but that's another situation. Like they could be snowbirds, all those types of things. Um, let's talk about those situations and what is, I believe you call it ancillary probate, and when does it apply?
So ancillary probate. So there's two types of probate: domiciliary and ancillary, with regards to residency. Domiciliary basically says this is where I resided when I lived. So if I own a cabin in North Carolina that I go up there for 2 months, it's not my permanent residence. It's just my vacation home. I would have an ancillary probate in North Carolina and a domiciliary probate for my assets in Florida. So when you have an ancillary probate in Florida, it's typically the snowbird situation where, hey, they lived in Ohio their whole lives. They don't really want to leave Ohio, but they don't like Ohio in January, February. So they come down here and they have a condo or they have a vacation home that they come and live in Florida. When they die, if they have that residence in their name, then there would be an ancillary probate. It's ancillary to the domiciliary probate in Ohio. And we would take care of the Florida property subject to their wills or intestate statutes.
Let's talk about if there's a contested will. How do you approach a contested will or suspected undue influence, or questions about capacity? I assume that refers to capacity of the person who has created the will.
Sure. So typically with wills, with regards, if it's being challenged, there's lack of execution, which means it wasn't witnessed properly or signed properly. Two would be lack of capacity, which is a difficult argument in Florida because it's a high standard to prove someone had
Mhm,
no capacity. And the third, which is probably, in my opinion, the most used and utilized, is undue influence.
mhm,
And that's typically what you see is mom or dad was starting to become susceptible to my brother's opinions and thoughts. And my brother calls an attorney and schedules the meeting for my mom and takes my mom in and sits in the meeting and tells her that, and she's being influenced. Not that she lacks capacity, but she's just so reliant on my brother,
mhm.
that she's easily being influenced by him, and it's no longer her intent; it's his. So I think those are the three main ways that you'll see challenges here in Florida.
Mhm. Okay.
What's really, really important, I think, is anytime there's a family that has a situation where there's going to be a probate contest, whether it's will, whether it's anything, um, you need to lawyer up quick because you want to immediately be represented. You want to immediately put a stop on any type of transfer of assets. You want to immediately put people on notice that there's an issue and that and it's called an adversarial action in the probate court. And you'll need to file the appropriate documents to say, hey, this isn't your standard probate anymore. This
Mhm.
isn't my brother and I have gone along our whole lives and we still love mom and dad. And we still sing Kumbaya by the fire after mom and dad died and everything's okay. This is, hey, my brother went and tried to steal everything from me at the last second, and
Mhm.
you have to be represented. So the biggest thing is if you suspect that, whether it's stealing of property, whether it's undue influence, all those type of things, you need to immediately hire an experienced litigation estate attorney. And I
Okay.
think it does not need to be a general practice litigator. In my opinion, you need to find someone that is experienced in the probate court that does litigation in the probate court because there are nuances that are different than a general litigation court.
Our next topic here about how to avoid some of those problems or how to make the probate process more streamlined, maybe future proofing. Sort of your general recommendation, right, is to have a good estate plan. And let's hope that those of you that are out there listening are listening before something has happened, before either your estate has to go through the probate process, or before you've lost a loved one. So what are some of the most effective ways to avoiding probate, or to make it simpler?
I think there's generally three ways that we can avoid probate. One is through asset ownership. And what I mean by that is my wife and I own an account that says Tom Moss and Carrie Moss as tenants by the entireties. Or you and I own an account, Danny, that says
Mm,
Tom Moss and Danny with rights of survivorship. Even if my will said I leave everything to Hunter and Parker, the first thing we look at is ownership. So if I have a joint owner in which there's survivorship qualities, it's directly going to go to that other owner. So one way to avoid probate is how you title your assets. Two is beneficiary designations. And I think that's become very, very popular, like on an IRA or a 401k or a life insurance policy or a bank account or an investment account. If I have an account that's in Tom Moss's name and I name my sons Hunter and Parker as the beneficiaries, then all they'll need to do is go to the bank or go to the financial institution or go to the insurance company, provide valid death certificates, and that money will pay to them because they were the designated beneficiaries. So that's the easiest way traditionally to avoid probate.
mm,
And the last way that I utilize to avoid probate is trusts. So when you think about probate, probate's the process of transferring assets that are in a decedent's name only that do not have beneficiary designations.
mhm,
So in that case, you look to the will. Well, if an asset is titled in the name of the trust, it's not titled in your name only. And as such, it avoids probate, and your trustee can be in charge of those assets immediately on your death to act appropriately to pay your debts, pay your creditors, and administer your trust estate without having to go through the court process of probate. So those are the three primary ways of avoiding probate. And again, there is no one size fits all. For example, if I have a child with special needs trust and I just name them as a beneficiary, yeah, I avoided probate, but I did a terrible thing. I didn't. Now my son's going to be disqualified from public benefits. I'm not going to help them. Who's going to take care of that child? Because now
mhm,
they're going to need a guardianship. So um, you need to have a qualified estate planner that understands everyone's unique. You shouldn't have some estate planner that has a Word document form that changes, Tom's name to Teddy's name and
mm.
prints it. That's 1960s gone. We need that. That's a long time ago. So depending on your situation, we can do a lot of different things. Some of my clients are very, very simple. They come in, we do a ladybird deed on their house, and it names the beneficiary on the deed. We put a beneficiary designation on their bank account. We do some power of attorneys. It's great. No problem. That's a fine plan for some people. Some people come in and my son's a drug addict. My son's a spendthrift. My daughter has an abusive spouse.
Mhm.
I want to make sure that when my daughter dies, it goes to my grandchildren and not to my son-in-law who's mean to her.
Mhm.
All those different circumstances require different answers that need to be done in the planning stage.
What are some of the red flags that you see with a personal representative that they need to get help immediately, immediate professional help?
I think when you have siblings or beneficiaries that are upset. Sometimes people are disinherited.
Mhm.
Sometimes they're just not happy. Sometimes people aren't. When you have a very difficult beneficiary, I think it's important immediately to get assistance. Two, when you have someone that's very pushy. For example, my brother's driving down from Atlanta and he brought a U-Haul with him and he's going to take everything from dad's house. Well, no, I need to safeguard the house and I need to make sure my brother understands that as part of the probate process, we have to inventory assets. It's not just to steal everything from
Mhm.
dad's house this weekend. So, you need to get a pretty firmly written letter from your attorney right away that no, you can't load up the U-Haul and take everything. And lastly, I think when there's people that had an expectation for inheritance that aren't getting an inheritance, um, not because of undue influence, maybe not because of bad nature, just because the decedent didn't want them to get something. And those people can get upset and pretty threatening pretty quickly. So
Mhm.
the personal representative needs to have guidance to make sure one, they know that they're going to be okay, that the law protects them and that the court protects them, and their job is to simply administer their will, and they're not
Mhm.
casting judgment as to whether it is appropriate or not appropriate. It doesn't matter. That's what that decedent wanted, and that's what the will says.